My Lords, I declare an interest as Chairman of the Bar Standards Board. The Bar Standards Board is the regulatory arm of the Bar Council, not the representative one, and I have no direct concern with the pay that barristers earn. My job is to further the objectives laid down for the Bar in the Legal Services Act 2007. There are 8 of them in Section 1, including protecting and promoting the public interest, improving access to justice, and encouraging an independent, strong, diverse and effective legal profession. What I have to say tonight when I encourage your lordships to annul this order is based entirely on the application of those objectives in the regulation of the education and working lives of barristers. Last Sunday, an advertisement appeared in the Sunday Times, headed, "Helping the Most Vulnerable in Society." It was for a new chief executive of the Legal Services Commission, which hands out legal aid. I quote from the ad, "Our role is to ensure through our providers independent, high-quality legal advice and representation is available to vulnerable people who cannot afford it themselves. We enable people to protect their rights and defend their interests." My Lords, this order flies in the face of the aspiration in that advertisement and in the achievements of the objectives of the Legal Services Act and the profession. Let me turn first to the effect it will have on women and black and ethnic minority barristers. This is a central plank of the work that we do at the Bar Standards Board in encouraging and retaining those very barristers. The effect of this order is to cut the rates payable in family advocacy by 10%. It will be felt most severely by women and black and ethnic minority barristers who are disproportionately present in dependence on legal aid work, while white men are the least dependent sector. There's been considerable government pressure to open up the legal profession still more to entrants from all backgrounds, albeit that it is already a very diverse profession. Alan Milburn's report of 2009 singled out the legal profession in his survey of social mobility. Even though the bar and solicitors go to enormous lengths to explain and reach out to young people all over the country, and the bar has a record to be proud of, with over 15% of pupillages going to black and ethnic minority students in a very competitive market. The cuts in fees in this order undo all that work and make the government appear two-faced. 60% of the family bar are women, and they do 66% of the legally aided children work. Half the family bar relies on public funds for more than 60% of their turnover. From their gross earnings, modest though they are, barristers have to pay overheads to chambers and clerks, typically 20%, and in addition meet their own pensions, illness and professional insurance cover and expenses. The King's College London survey of barristers in 2008-09 indicated that 80% of them intended to abandon legally aided public work. This generation of young people have university tuition debts, huge fees at bar school, and the modest but reliable income that was once their support in the early years at the bar is now to diminish to such an extent that they cannot earn a living. There's no point in the great efforts put into outreach in this situation. It continues on into the judiciary. The noble lady Baroness Neuberger reported on judicial diversity in 2010. A less diverse profession means a less diverse judiciary and fewer women judges. The diminution of the profession also means more litigants in person, taking up more court time, not less, and with problems being stored for several years down the line because they can't be settled in court in a proper and timely way. As with other demanding professions, women are being lost to the bar after 5 to 10 years in practice because of the cost of childcare. It is unaffordable and will be even more so. Twice as many women leave the bar as do men for that reason. So the fees cut in this order will weaken retention. It will also damage the children who are the subject of court orders, because now the experts who give evidence in child cases are placed within this table of reduced fees, and the fees are set at below the level needed to maintain their practices. The government has given no evidence reason for cutting by 10%, and it hasn't waited for the outcome of the Family Justice Review, chaired by David Norgrove. In March of this year, its interim report commented on the adverse impact that cuts would have and the lack of data about case handling and flow through the courts, and the contribution made by the lawyers in the cases. In the 2009 study, Family Law Advocacy, by the very experienced researchers John E. Killar and Mavis McLean of Oxford University, it was shown that where lawyers were involved in family law cases concerning money and children, the majority of cases were resolved without court process or contested hearing. Even where the cases went to court, in the highly charged, emotional atmosphere that one would expect, the presence of specialist family lawyers enhanced the prospects of resolution and shortened the court process, for they are minded to act collaboratively and in the interests of the children. Additional damage has already occurred to women and children through the closure, because of already instituted cuts, of the advice agencies Justice, Refugee and Migrant, the Immigration Advisory Service and Law for All, as the noble Lord Bach has just mentioned. There are more constructive ways to save money. First of all, there is too much judicial review, now used as the citizen's right of appeal. I was surprised to find, when I was the independent adjudicator for higher education, running an alternative dispute resolution service for students, that those students obtained legal aid to challenge our decisions. There should be a pushback against the notion that human rights means that any and every decision can be judicially reviewed at great cost to the public. As for human rights, the real denial of them is to the middle classes, who are neither poor enough to be eligible for legal aid, nor can they afford to go to law at their own expense, and are therefore the real victims who cannot access justice. The other substantive reform needed is to bring certainty into the law of maintenance on divorce. An obvious model for this is the continental European system of community of property, to which the Scottish system is similar, which entails a fixed 50-50 split of post-marital property and little ongoing maintenance. Broad-brush justice it may be, but cheap and efficient to arrange. As long as we have our Rolls-Royce discretionary system of settling property issues on divorce, couples will continue to waste sums they can ill afford, sometimes amounting to as much as the property in dispute, on deciding who gets what. My Lords, this order should be annulled, and the government should await the Family Justice Review report and change substantive law to get a more efficient system without damaging the profession and its diversity.
My Lords, I too support this motion and agree with nearly all the remarks of my noble friend, Baroness Deach. Lord, the statutory instrument is, I suggest, an extremely worrying document, proposing as it does to reduce by 10% the remuneration payable to lawyers for legal services in cases covered by a legal aid certificate. Now, my Lords, what is the reason for this? The purported reason is set out in the explanatory memorandum. Paragraph 7.2 explains that, quote, "The government considers it needs to ensure that it only pays those fees that are absolutely necessary to secure the level of services that are required." Now that is an entirely acceptable proposition, but I suggest, my Lords, that it's weasel words. The reason is not that legal aid should not have been granted in a number of cases. It's not that the remuneration assessed under the present regulations exceeds a reasonable charge for the work done. It's not that the work done was unnecessary. The reason is that assistance is needed from the Ministry of Justice to help reduce the budget deficit. Why that could not have been explained as the reason in the explanatory memorandum, I know not. But that is plainly the reason. It is simply to assist in reducing the budget deficit. Now, are others who do work for the government as independent contractors, like barristers or like solicitors, to have their remuneration reduced to assist in reducing the budget deficit? I haven't heard of such a suggestion. Why is it that legal aid lawyers are being singled out for this attention? The effect of the 10% reduction needs to be thought about. A number of lawyers may decline to accept legally aided work, bearing in mind that they will, under it, receive 10% less than the sum which would have been reasonable remuneration under present standards. Why reduce what has been assessed as reasonable remuneration? A second possible result has already been referred to by Baroness Deach. Litigants in person, the number of them may increase. The presence of litigants in person in court almost invariably means that the case takes much longer. It often means that there are going to have to be adjournments. The judge with litigants in person before him, particularly if there's one litigant in person on one side and counsel for a paying party on the other side, is placed in the position of having to appear sometimes like counsel for the litigant in person. The judge thinks of points that the litigant in person hasn't thought of that assist the litigant in person's case, puts those forward, and then it appears as if he's taking the side of the litigant in person. It's an unedifying spectacle, but all judges will have experienced it, and I have myself. Those are the possible adverse consequences. Well, what are the beneficial consequences? A reduction in the legal aid bill? Well, that depends upon what the additional cost occasioned by having litigants in persons, having many more adjournments, may bring about. The Law Society has, I know, circulated some documents suggesting that the notion that costs will actually be saved by these so-called reforms are misconceived. That's as it may be. It may be only pie in the sky, but at all event, the proof of the pudding will be in the eating, and the disadvantages, I suggest, are apparent. But more important than the disadvantages to which I've referred is, I suggest, the effect on the civil justice system. Now, the civil justice system is something that I have a great affection for. I've worked in it all my working life. It is a system that is not an optional extra. It is a system that it behoves every government to supply for the benefit of all its citizens. Without a civil justice system, self-help would become the order of the day in the settlement of issues between citizens. The civil justice system is there to settle issues between citizens and the government. A feature of an acceptable civil justice system is that it must be accessible to all who need to use it. The legal aid scheme enables that to be achieved. There are some types of litigation which are removed from the benefit of the ability of the litigants to conduct their cases under legal aid. But broadly speaking, the legal aid scheme seeks to ensure that access to justice, to the civil justice system, is going to be available to all, which is right and proper. As I've said before, it is not an optional extra to be paid for only by those who can afford to pay for it. The need for lawyers in that system is apparent also. Lawyers who work in the legal aid system also need to be paid for. And the notion that that can be avoided by government is no more realistic than saying that any other necessary service which it behoves government to provide should be paid for by those who work in it. Are doctors and nurses supposed to contribute to the cost of the National Health Service? Certainly not. How is it a different case where legal aid lawyers work in cases where legal aid has been granted? A functioning and healthy civil legal aid system is, I have said, an essential. The implications of this statutory instrument suggests that the government does not regard it in quite that light, but thinks that these impositions on the lawyers who work in that system can be made in order to reduce the cost that would otherwise fall on government. The implications of the 10% reduction do not perhaps matter very much for senior barristers who have established a practice. They will have some privately funded work. They will have established a goodwill among solicitors and clients that they can rely on in legally aided work as well. They will survive the 10% reduction. But the ones who will be struck by it and who may not survive it are the new entrants to the profession, the men and the women who enter the profession with trepidation. It's a profession which provides no security. There is no firm that will pay you a salary that you can fall back on. You stand or fall on your own efforts and rely on the fees that you earn. And I suppose almost every entrant into the profession, on entering, will wonder how long he or she can manage to continue before the financial difficulties become too great. The statutory instrument separates counsel who provide advocacy services under the legal aid scheme into senior barristers who've been in practice 10 years or more, and juniors who have been in practice less than 10 years. Well, now, those who've been in practice for 10 years or more can be expected to have built up some degree of practice and goodwill. They probably have some privately funded clients. They probably have some goodwill with solicitors who do legal aid work. They can probably avoid suffering too much from this 10% reduction in their legal aid income. But what about those new entrants, 5 years call or less? They have no security at all. They will have a meagre income. They will hope that it builds to something respectable, and many of them do, but some of them don't. I suppose practically every barrister who enters the profession does so in the knowledge that he or she may be unable to afford to continue for long enough to establish a practice on which they can reasonably live. They may have to take a boat hole, so to speak, into employment in a solicitor's firm, into employment in the legal department of some commercial company. And the ones who have to take that course, who can't wait the length of time necessary to build up a practice they can survive on, will be those who have not got any advantages of family support to help them in their difficult years. Well, this statutory instrument is going to make those first 5 years much, much more difficult. Imagine somebody on an employment salary, not a very large one, told that he or she must suffer a 10% reduction for the future. There will be a drift away from the barrister's profession and into the firms and commercial companies to which I've already referred. It will do a disservice to the civil justice system, which depends upon a stream of lawyers coming up through the system and becoming available eventually as potential judges. I respectfully suggest that this is a bad statutory instrument, and if my noble friend Lord Bach does put it to a vote, I shall vote for it.
I regret that I must also support the noble Lord Bach's motion because of my concerns about the impact on child welfare. I regret doing so because I know the government has the welfare of children very much to heart, and I do thank the noble Lord the Minister for ensuring that domestic violence issues, I think, are kept out of this, and also that the tandem representation of children in private law cases will continue and will be untouched. But if I can just remind the noble Lord and members of the House of Article 3 in the United Nations Convention on the Right of the Child. In all actions concerning children, whether undertaken by legislative bodies or other institutions, the best interests of the child shall be a primary consideration. So I'll be very interested to hear from the Minister in his reply how the best interests of children have been considered in this move from the government to cut legal aid in these circumstances. My Lords, my concern is children need the best experts and the best lawyers in the immensely complex, often, cases that they are drawn into, and that these experts will be driven out by the further cut to their finances. My Lords, for instance, the expert witnesses to the family courts, the paediatricians, the child and adolescent psychiatrists, the educational psychologists, the adolescent psychotherapists, the independent social workers, are all touched by this. They are subject to this 10% cut. They've recently had their fees already seriously cut. And for clinicians working in London, the situation is worse because London-based practitioners are only allowed to charge 2/3 of the amount that those based outside of London can charge. And as everyone knows, the cost of London, in reality, it's more costly to practice in London. So, my Lords, I am very concerned about the impact on this workforce, into the expert witnesses, that there will be further delays for children in the courts, that there will be poor decisions, and if a child is taken into local authority care, if he's taken in and the wrong decision is come to, that will stay with that child for the rest of his life and possibly the rest of his children's lives. So we need to get those decisions right. We need the right expertise. My Lords, and a further concern of the expert witnesses is that they cannot deal directly with the Legal Services Commission. They have to work indirectly through solicitors. And perhaps this is something the Minister could look at, because this would certainly be an improvement if they could deal directly with them. My Lords, I look forward to the noble Lord the Minister's response, and I do hope he can give some comfort to your Lordships.
My Lords, I rise with a heavy heart to speak against this annulment motion. With a heavy heart because all my professional life I've been a devoted supporter of legal aid, and I declare an interest as a barrister who over the years has done a great deal of publicly funded work. My first ever motion to a Liberal Democrat conference was on the promotion of legal aid. The Liberal Democrat Lawyers Association, which I chaired for a number of years, drank a toast every year at its annual dinner to the Legal Aid Fund, a toast proposed by a prominent lawyer. And it's noteworthy in the context of today's debate that the toast was changed some 10 or so years ago to Justice for All, as an ironic response to cuts in civil legal aid made by the then Labour government. I chaired a policy group entitled A Right to Justice, which helped to define Liberal Democrat policy on improving the legal aid scheme. And my party has always taken as its starting point for discussion on this topic that access to justice is a crucial right and that legal aid funding provides a vital public service. There is no point in having rights enforceable at law if citizens cannot secure those rights in courts of law. And I know from many years' experience of him that that is a position that my noble friend the Minister takes as well. But while there is much to agree with in all the speeches that have been made so far in favour of this motion, we live in difficult times, and as the noble Lord Bach fairly acknowledged, savings must be made. The provisions of this order are estimated to deliver 120 millions of the £350 million savings the Ministry of Justice is required to make in legal aid over the spending review period from 2011 to 2015. My Lords, if we do not make those savings, matters can only get worse, and later cuts will have to be deeper. On a personal note, in Greece, my wife's home country, I've seen at first hand the effects of the extreme austerity measures cutting back public expenditure, which cuts could have been much less harsh had the government there got a grip on the public purse earlier, when all the signs of overspending were plain for all to see. The need to make savings in the legal aid budget was recognised by the Labour Party in government, who made some 30 attempts to limit it, reducing fees in real terms across the piece as they did so between 2006 and their leaving office. Furthermore, that was before the full extent of the deficit became apparent and the need for deficit reduction and cuts across the board became as clear as it is now. On the 18th of May 2009, the noble Lord Panic asked whether the Labour government would maintain the rates of legal aid payments in family law cases. The noble Lord replied, "Family law legal aid costs have risen unsustainably from £399 million per year to £582 million per year in the past 6 years. We need to control these costs in order to protect services for vulnerable clients." In the consultation paper sent out by the Ministry of Justice in July of that year, for which Lord Bach was responsible as the legal aid minister, his proposals were described as follows. Our legal aid system is one of the best funded in the world. We spend about £38 per head on it annually in England and Wales, compared to £4 in Germany and £3 in France. Even countries with a legal system more like ours spend less. For example, both New Zealand and the Republic of Ireland spend around £8 per head. My Lords, I should interpose that I regard the fact that we still spend considerably more than comparable countries on legal aid as a matter for pride. And that is still the case. But it does highlight the degree to which the legal aid budget must bear its share of the economies that have to be made. The Labour government's consultation paper continued. While we devote considerable resources to legal aid, £2 billion annually, and the figure is now 2.2, our resources are limited, and we need to review regularly how legal aid funds are being spent and whether we're securing value for money for the taxpayer and providing the services that the public need. In the government's response to the consultation, published in January of 2010 and signed by the noble Lord, it was said the government wants to ensure that we rebalance the legal aid budget as far as possible in favour of civil help for those who need it most. But we also need to ensure that the resources we currently devote to civil legal aid are being targeted appropriately, and that the rules for granting funding are as robust as they need to be to ensure that resources are expended on meritorious cases. The intended effects are to redirect resources onto higher priority areas and to ensure that funding is only granted to eligible clients. The words rebalance and redirection of resources would inevitably have involved real terms reductions in fees. And in their election manifesto last year, Labour said, to help protect frontline services, we will find greater savings in legal aid and the court system. And when this government's consultation paper on legal aid was published, Lord Bach very fairly said, as he has said tonight, it would be hypocritical of Labour to say we'd not cut anything. If we had, we'd be rightly criticised. My Lords, it is beyond doubt that the reductions in fees embodied in the order, which the noble Lord seeks to annul, do make it more difficult for the already hard-pressed community legal practitioners mentioned in the motion to thrive, and will make it more difficult for barristers, junior and senior, who work on publicly funded work. We agree entirely with the noble Lord that such practitioners carry out an essential service for those least able to afford it. And this order does involve a 10% cut in their fees and in the fees of barristers for publicly funded work across the field of civil and family law, not just social welfare law. And it includes, and I would suggest rightly, a limit on experts' fees for the first time. It is going to be more necessary than ever for lawyers to practice as efficiently as they can, and the harsh reality is that they will earn less from legal aid work. But I am far less clear that their core viability is threatened. My Lords, we will be debating these issues and the other issues about the scope of legal aid mentioned by the Noble Lord, but not the subject of this order, in full when the Legal Aid Sentencing and Punishment of Offenders Bill comes to this House shortly. I hope we'll also be able to explore during the course of this Parliament other ways in which savings might be made without damaging the quality of the justice system. Progress is being made in exploring the achievement of savings through alternative dispute resolution procedures. I believe there is also room for improvement in the efficiency of the court system to produce savings. And in the family field, I look forward with great hope to the final report of the Family Justice Review chaired by David Norgrove. I would make it clear from these benches that we have been and are heavily involved in discussions with practitioners and others, including many civil and family law practitioners, both barristers and solicitors, who've quite rightly expressed their concerns to us. And we will examine closely with ministers whether and how far the bill achieves fairness and the protection of the vulnerable in the use of extremely limited resources. We would hope and expect that in due course in a reviving economy, any gaps in provision which emerge will be refilled. However, that there must now be some cuts in fees is inevitable in these straitened circumstances. And in advancing this annulment motion, I suggest that the Noble Lord and the Labour Party need to tell us what choices they would have made or would make now in cutting the legal aid budget. What were the cuts that he was intending to implement, and how would they not have threatened hard-pressed community practitioners? And, my Lords, until those questions are answered fully, I suggest that however regrettable the need for fee cuts is in civil and family proceedings, it would not be sensible to divide the House on this motion.
Lords, I'm grateful to the Noble Lord Bach for raising this issue tonight and for concentrating my thoughts, like those of the Noble Earl Listowel, on the welfare of children as they are treated by our legal system. Well, Lords, we spent the whole of this afternoon talking about the treatment and rights of children. And I look forward to the government's response and comment on the ways in which children can be particularly protected in our legal system by the way in which the distribution of fees is arranged throughout that system. And I think I'm a bit puzzled still by the words of the Noble Lord Marx in terms of why it should be this area in which we look for particular savings. A number of Noble Lords have spoken of areas in criminal law, for example, where there could be significant savings. Why this area? I think of the work of, for example, Henry Hyams, who are solicitors in Leeds, who take some 2,000 cases a year or so from the most deprived areas of Leeds, and who tell me that almost all of those cases involve the welfare of children. And that takes us on to the effect of these cuts on those clinicians who provide reports to assist the courts in making determinations about the safeguarding of children. Professionals who provide evidence of injury and of abuse, and who are often key to the welfare of children. We've improved immensely our understanding of child care in our society, and much of that's been due to the diligence of such professionals. We're all made very aware when a mistake is made by one of those professionals. We forget the thousands of cases where accurate decisions are taken about children's welfare and children's future. And it seems to me, my Lords, that the debate we've been having all afternoon and this debate come together in looking at the well-being, again, of children and of their place in our society. My Lords, clergy in pastoral work are often aware of the time spent both by those clinicians and also by lawyers with their clients seeking the best way forward for children and family life. Often work which is undertaken quite outside the fee system. We claim, my Lords, to be a society which puts the family first. Social welfare law is an important part of enabling us to do that. The noble Lord Marx spoke of the way in which he hoped that if there were gaps in our provision, they would, as the economic situation becomes better, be able to be filled again. But, my Lords, the most important part of our response to the difficulties in which we currently find ourselves is that those who are most deprived in our society should be those whom we seek to protect from the cuts which are being made. The government and many local authorities seek to do that. And yet, in this particular instance, it seems to me that those cuts are actually bearing at their hardest on those who are least able actually to bear the brunt of them.
Lords, I have three categories of interest to declare. The first is professional. Unlike a number of your Lordships have spoken, not as a member of the Bar, still less as a most distinguished judge, but as a mere solicitor and now an unpaid consultant in the firm of which I'm senior partner for some 30 years. The second is a political interest because, as my noble friend will recall, it was a resolution that I was responsible for which went to the Labour Party conference some 3 years ago and which led to, somewhat critical it must be said, rightly so I think, of the then government's policies on legal aid, which led to the establishment of a committee which the noble Lord Bach chaired, on which he was gracious enough to invite me to participate. And the third is a personal one because the noble Lady Baroness Deach and I graduated at the same time, it's all of 46 years ago, in the Honour School of Jurisprudence at Oxford. My Lords, it does seem to me that this order, coming as it does shortly before the legal aid and sentencing bill reaches your Lordship's house, that the order is really something of a tawdry harbinger of what is very likely to be a prolonged and hard winter for access to justice. It's interesting that the young legal aid lawyers, in a briefing note that they have circulated, drawn attention to the fact that the consultation which the government entered into on its proposals to reduce these fees was very limited. They consulted only the Law Society and the Bar Council. There was no consultation with other stakeholders, law centres, community groups, Citizens Advice Bureau, or indeed any client interests. This does not seem to represent the no decision about me without me process, which was allegedly followed in terms of the health service. But more importantly, that body of young legal aid lawyers pointed out that the National Audit Office have issued a warning about the process which the government undertook. And they quote the National Audit Office as observing that there was a risk to the sustainability of the supplier base arising from the fact that remuneration for legal aid work is often unfavourable compared to other legal work, and that proposals such as these, the ones that we are in fact currently debating, have the potential to increase that risk. In other words, the supply side is likely to diminish. And that is surely inconsistent with one of the favourite mantras of this government, perhaps rightly so, which is to increase choice. If you reduce the supply base, you restrict choice. My Lords, I've been looking into and discussing with the Law Centre in Newcastle the impact of these reductions in fees on that organisation. It's an organisation which employs 3 solicitors at an average salary of around £29,000 and 2 qualified caseworkers at around £25,000. By no possible stretch of the imagination could these be described as fat cat lawyers. Some might regard them as potentially half-starved lawyers, but certainly they are not well paid by comparison with those in private practice or in commercial organisations. Interestingly, the organisation also engages in the work of 8 volunteers. In the last financial year, it advised 2,000 people and it opened 550 active files. That's a substantial workload. As a result of the fees decision of this order, they're likely to lose some £20,000 a year. Their salaries, of course, have not been increased since 2009. The fees have not been increased since 2008, when the last government last increased them. And, of course, we're now in a time of considerable inflation on non-salary costs. So they're not just getting a 10% cut in the next year, they'll be having a 10% cut on top of inflation and on top of no real increase in the last few years. In addition to that, they're faced with the prospective loss of £60,000 a year from the Equality and Human Rights Commission. It's not yet clear, and I don't know whether the Minister will be in a position to indicate either when or what kind of decisions will be made about this sort of funding, whether that will be continued to any extent. They've also, in the current financial year, sustained a loss of £30,000 of the £95,000 grant they received from the local authority, Newcastle City Council. It's now £65,000, and given the scale of the cuts in grant that the authority has received, it can be by no means assumed that the grant will be sustained at that level. One hopes, and there are 2 members of your Lordship's House who might be arguing that case, that the grant will be sustained, but certainly no guarantees at all can be given in that respect. This is an organisation which at the moment is carrying out important work in the realms of asylum law, immigration law, consumer law and employment law. And it's facing a very, very fraught future with a significant impact on the people who use its services at the moment. I repeat, 2,000 advice cases, 550 active files opened in the last year. That's a significant number of people, and many of them will be unlikely to be assisted. Moreover, demand will increase as a result of the prevailing circumstances in the economy, and also because of the potential impact on private practice of the fees. I've had discussions with a leading northeast firm, which is largely a legal aid firm. It depends about 80% of its fee income on legal aid. Interestingly, the salaries that are paid there are also pretty modest. The senior solicitors in their legal aid departments earn all of £40,000 a year. Less experienced solicitors are on £24,000 a year. They have a number of caseworkers on between £16,000 and £18,000 a year. Not, again, you might think, exceedingly generous salaries. Some of the departments are barely covering their costs at the moment, and that's before this fee cut and indeed before taking into account a rising inflation. There's also a significant question about the issue of the funding of family law, to which others of your lordships have referred, and again I don't know whether the Noble Lord the Minister is able at all to indicate either when decisions will be made about that or whether they are likely to match or differ from the current position. But it's clear that that firm, and it's a very significant player in the local legal economy, will be able to sustain the breadth of its operations. And again, if they were have to reduce their staffing and the coverage, again, that will again restrict the choice of those who need legal advice. The firm I am consultant with has for some time effectively sustained its criminal department on the basis of, in fact, some years not covering its costs and some years barely covering its costs. It's been able to do that only because it's been relatively buoyant in other areas. But it cannot be expected that firms in the private sector will be able to continue effectively to provide a pro bono service even for criminal legal aid. Although that is an area in which particularly, and I might say so, in the presence of those who have affiliations with the bar, that's probably where the savings actually need to be made, as well as in the court system, rather than at the end of the solicitors. But there is a real risk, again, of that supplier base being undermined and with it choice being restricted. The Noble Lord Earl Listowel referred to the issue of experts, and that it's perfectly reasonable to look at the fees payable to experts and to develop a system in which they can be perhaps better controlled. On the other hand, expert advice is often needed. The large firm to which I referred before, for example, instructs experts, country experts, for example, in asylum cases, medical experts in welfare cases, and again, it's reasonable that they should be properly, not over generously, but properly remunerated, because again, there could be a significant impact on the supplier base of important people with a very significant role in the administration of justice. Also, I heard what the Noble Lord Bach said about the annual Liberal Democrat lawyers get-together, and I hope that they will again be toasting the access to justice and the legal aid system. Perhaps not next year in the light of these circumstances with claret, but more likely bowls of thin gruel. Because it does seem to me that we are facing, with the combination of this measure and what is to come, a very significant attack on the legal aid system, and it's perhaps no coincidence that takes place at a time when we're also debating the future of the National Health Service. Many members of your Lordship's House last night paid tribute to the post-war Labour government and the creation of the National Health Service as something which was a great achievement in social policy, a great pillar of the welfare state. Many of us, not all of us, but many of us, particularly on this side of the House, think that that achievement and that pillar are threatened with being substantially undermined by the National Health Service, by the Health and Social Care Bill. Well, that's a matter we'll be debating at some length over the next few weeks. But it is clear that, whether that be the case or not, that there is a real threat to the legal aid system, that it is facing effectively, potentially being dismantled, and that access to justice, which was one of the great achievements of the post-war Labour government and was a fundamental part of the welfare state that it then developed, is severely at risk. My Lords, I do not know whether the Noble Lord, my noble friend, will be dividing the House tonight. It would be perhaps unusual for this House to divide on such an incident of this kind. But if he does not, we will, of course, be returning to the substantive issue, the greater issue, of which this is a trailer, I suspect, when we look at the legal aid bill. And if your Lordship's House does not significantly amend that bill, then access to justice will be significantly diminished. And with that, there will be a significant diminution in the quality and breadth of the welfare state and the society which that great post-war government sought to create and foster. And I do hope, my Lords, that the government will think very carefully before it does further damage to something which, as the Noble Lord Bach said, we have all been proud of for the last 60 years.
Yeah. We live and learn. I apologise to my noble friend on the front bench for my slowness in getting up. and possibly partly for what I'm going to say as well. But we do live and learn. I always knew I was I was more liberal than the last Labour government. I now know that I'm more liberal than the Liberal Democrats, at least as represented in the House tonight. Now, I hope my noble friends on the front bench haven't reached the stage of trembling when I stand up, because I'm really quite a nice pussycat, but by comparison with some, at any rate. But I can assure them that were this to be pressed to a vote, I would not vote for it, because I don't think it's right for us to be killing off statutory instruments in the way that this would do, certainly with the way the House operates at the moment. But I do think it's important that somebody from these benches should make it clear that even if we would not want to see this voted down, we are not happy bunnies about the policies that seem to underlie this. And there are those of us, as I think I've already warned my long-suffering whip there and others, who are likely to want to return to some of these issues when we get to the bill that is coming down the track towards us. And I have to say that I think the speeches that have come in this debate from the Lord Bach, from the noble Lord Bach, from the noble Lady Deach, from the noble and learned Lord Scott of Foscote, and others, including Lord Listowel and the Bishop, and everybody bar one, dare I say, who has spoken, have made a pretty devastating case about, well, the Minister may, well, I'll listen to his answer, and I'm a notoriously pliable chap. If I'm convinced, I will be prepared to change my view. But at the moment, I think they've made a pretty devastating case. I only have one question to add to those that have been asked, which is about mental health, where locking people up remains one of the areas where you can get legal aid for the Mental Health Tribunal. Now, when I was, and I think this is relevant to this area, when I was still, and it's 2 years ago now, when I was still chairing the Administrative Justice and Tribunals Council, the Ministry of Justice, under its former incumbents, had, or the officials at any rate, had asked the Council, and particularly me as its chair, to chair the user group for the mental health tribunals. And this is a little less comfortable with the opposition front bench. Even at that stage, the mental health lawyers were expressing the view that the cuts that had been made in legal aid remuneration were, at least in some parts of the country, making it virtually impossible to find people to represent people before the mental health tribunals. It was particularly true in the southwest. I think there were some concerns in the northeast, but certainly there were concerns, even with the policies that had been previously pursued. Now, I therefore just want to ask two questions of my noble friend, on the front, my noble friend the Minister. Does mental health, or is it potentially affected by this? And what is the position about the availability of legal aid lawyers to help mental health claimants, persons confronted with the possibility of being deprived of their liberty in relation to mental health tribunals? And it ties in with the point that the noble Lord Beauchamp has just made very effectively. The net result of this may well be to reduce the amount of work and support available to vulnerable people, not only because legal aid is not available, but because growing numbers of people, young lawyers who do pro bono work, will not be able to afford to go on doing it. So it seems to me, and this is a worry for many law centres and the like. So I'd like some comment on that. Lastly, I would just say to this, so to avoid being too unfriendly to my noble friend Lord Marx, it is the case that a lot of cuts that did a lot of damage were done also by the last Labour government. and I think that ought to be acknowledged. It is the case that we do need to find savings in various places, and the Ministry of Justice can't be excluded. But the fact is that if these sort of proposals, either under the last government or this one, are ending up bringing damage and trying to save our nation at the expense of the most vulnerable people, whether families, children, battered wives or mental ill cases, that does raise some questions. It raises questions about whether the Ministry of Justice is not being asked to find too much, perhaps, and certainly whether it is finding their savings in the right way. And I do say to my noble friend Lord Marx that the same thought had occurred to me as had evidently occurred to Lord Bach. If we can find £250 million to ensure that local councils provide rubbish collection services, which some of them are already able to provide with weekly collections of food waste, I do question some of the priorities here. So I make no apology for making an uncomfortable speech. If it's pressed to a vote, I won't vote for it, but I'm not very happy with what we're being asked to support.
To say, my lords, that I've enjoyed listening to the experts in law and legal aid, and I would just like to say that I think it's deeply unfair that a 10% cut should be put on one section and one section alone of a service that's paid for by the taxpayers. Today, the Law Society was here to talk about the future legislation that's going to come before this House. And I asked the question, what do lawyers earn in the legal aid field? And they said that the young lawyers are earning $25,000, and that's been mentioned here. Now, they rightly deserve it, but there are many manual workers, tradesmen and semi-skilled people who are earning that type of money, and they work hard for it. But we're putting on a 10% cut. And as Lady Dench said, that many of the people who are working in this particular service are women. And I know there's not a lot of sympathy for members of Parliament at the moment, but I met a former colleague, a lady member, and she was saying that a substantial part of her salary goes in childcare. Now, the childcare, there's no doubt about it, the childcare has gone up. And for those who are working as solicitors, young mothers, then that's going up. Any of us who drive a car will know that every time we go to a forecourt, that prices are going up, and legal companies need to travel, they need to get to court, and it's not just in London. So I would think it's extremely unfair, and I'm surprised. The Minister was at one time a member of a trade union. I don't know if he still is, but I think T&G would be in, wouldn't he? I don't think any organising the transport and general workers would want a cut of 10% on the workforce and take it lightly. So why should we do this? But in my constituency that I previously served, the place I was raised in, that by a decision of the Home Office, a great many men and women who were asylum seekers came to live in my community. And more often than not, that they came and they got advice from those who were legal aid practitioners. And it ended up that whilst those asylum seekers were coming to me, they were also at the same time going to the legal aid practitioners. And what I did was be able to form a good working relationship with those practitioners. And I found that they were doing far more than they were doing things over and above their duty as solicitors. They were working outside office hours. They were going to people's homes to try and assist them and help them. And these are the people that we're going to impose cuts on. As the noble Lord says that cuts have got to be made, but we've got to look at how we implement the cuts. And it's the easiest thing in the world to say, right, 10% across the board. That's the easiest thing in the world to say, but it's not necessarily the right thing to do. And I would urge the Minister that he should reconsider this matter at a time when many of the young people who are in this profession, they can't even get mortgages because of the difficulty to get mortgages, and they're having to get into the rented sector. So their overheads are far more than what they used to be. And I can recall times when